When it all falls down, literally, whose fault is it? This is an accident on a construction site where a crane was being used to lift roof trusses up to the top of the building. That collapsed. There's a lot of finger pointing on why that happened and who exactly is responsible. There's the crane operator, there's the company that was doing the work, and then there's the supervisor who may or may not have been in charge of the whole thing. It's kind of interesting. Just to add, I don't know who Buddy Socks is. He's not part of this case, but dude has the coolest name ever. I love it.
Okay, now we are on to what is our last case of the day, or the morning, which is D-1-GN-20-004005. This is Nelson Mejia and Antonio Guzman Ruiz versus Alamo Crane Services and James Edmonston. We are here on a motion for summary judgment and no evidence motion for summary judgment. I did read these motions, and it appears to me that there are, at least I think, what's set today, and you all tell me if I'm wrong, because when it gets this close to the holidays, sometimes things can get a little exciting here at the Travis County District Courthouse. I think what's set today is third-party defendant Peak Design Bills LLC's no evidence and traditional motions for summary judgment and motion to sever, and third-party defendants Rock Framing LLC and Carmen Guzman motion for summary judgment. Is that correct? Can someone help me? Are those the two things set?
That's correct, Your Honor.
All right, very good. Okay, let's have announcements first in the summary judgment pertaining to Peak Design Build. May I have announcements first by the movement and then the respondents?
Yes, Your Honor. For the movement, third-party defendant Peak Design Build LLC, it's Alan Moore.
Hello, Mr. Moore.
Morning.
And who's here on behalf of the respondent?
That would be me, Your Honor. Christopher Carl for Alamo Crane and James Edmiston.
Okay, very good. Okay, so let's start with this motion. I read the motion. I did not see a response in the file. There may well be one, but sometimes it takes a while to catch up. So I have read the motion. Yes.
I apologize. I filed a response a week ago and I uploaded it to the Box account last night.
Well, obviously, I didn't see it, or I would have read it. I'm not saying it's not there. And it coming into Box last night doesn't necessarily get it into my hands in time to read this. So I am pretty familiar with the motion itself. Let me just tell you what I see here. Is this, we're really talking about Peak Design. They're saying that there was no duty and no breach. They rely on this base agreement here, contractor base agreement. Independent contractor base agreement, which they quote from in their motion. They place the liability on Guzman. I'm sure others have something to say about that. They do cite to Supreme Court case JLB Builders versus Hernandez, which is a 2021 Texas Supreme Court case.
This is the case that they're referring to, and it's actually cited by pretty much every party involved in this case. And what it relates to is, well, the ruling was a general contractor owes a duty of care to its independent contractor's employees if the general contractor retains actual or contractual control over the means and methods of the independent contractor's work. The issue in JBL Builders was whether the general contractor on the construction project owed such a duty to a concrete subcontractor's employee who was injured on the job. The Court of Appeals held that the fact issue existed as to whether the general contractor exercised sufficient control to give rise to that duty of care, and they reversed the trial court's summary judgment in the contractor's favor. The Supreme Court agreed with the trial court that no genuine issue of material fact existed regarding the existence of a duty and reversed the Court of Appeals judgment. So a lot of what's in question here is whether Peak Design actually retained control over the work that was going on with the crane operation, bringing the crane to the site, and things like that. This case is actually a major case in Texas construction law.
Which they go into some length, and again, they say a general contractor has no affirmative duty to take action even upon learning of an independent contractor's unsafe conduct. And that Peak was not asserting actual control over the means and methods of work performed by plaintiffs or plaintiff employees at the time of the accident. So that's kind of where they are with it. All right, and I thought it was pretty persuasive motion, but I do want to hear from you, Mr. Carl. Tell me why this motion is wrong, and then I'll hear from you, Mr. Moore.
Thank you, Your Honor.
Well, Your Honor, I hesitate to call Mr. Moore wrong. However, I have presented the court with evidence in our response, essentially showing that there is evidence that there was actual control over the manner and means of the work that was performed that caused the injury.
What was that?
Well, in particular, if you like, Your Honor, I put together a PowerPoint that sort of generally outlines our position. Considering that you haven't seen my response,
Yeah, I'll look at your PowerPoint. That's fine.
Okay. All right. Do I have permission to share my screen?
Yes.
All right. You'll give me just 1 second to get set up.
I just wanted to cut this a little short because I had read Mr. Moore's entire argument. So that's why I turn it over to you right now. So you got the first word in, since I didn't see your response in the file just yet.
Well, I tell you what, that's the fairest I've been treated in quite a long time. Thank you so much, Judge. All right. So just very quickly, we also cite to the JLB builders. And we agree that there is no general duty to ensure safe work unless, of course, the employer retains some control over the manner the contractor performs the work that causes the damage. That's essentially the evidence that we're going to be showing. Now, I'm sorry, Judge?
I said, okay.
The proof of the control is made when we show some evidence that there was actual control over the manner in which the work that caused the injury was performed. Now, to begin, I'd like to, Judge, and I think a little bit of background into this would be important for you to understand what occurred in this situation. So I put up on the screen for you a artist's rendering or an architect's rendering of the Cherry Peak Office Park that's kind of near Lakeway. What this is it's a 16-building office condominium complex with individual buildings that were the property was owned, developed, and the construction was generally contracted by Peak Design. Now, again, it's comprised of 16 buildings. To the date of this particular incident, 4 buildings had been constructed. So 16 independent buildings built in sequence. To the date of the incident, about 4 buildings had been constructed. The majority of the buildings constructed on this property were shells. And what this means, Judge, and if you read the transcripts that we provided, the shell is essentially all exterior walls and a roof. This allowed the ultimate tenants of those buildings to move in and build out the inside however they wished. There were no eaves. If you take a look at that photo that's provided in my motion, there were no eaves. These roofs were of a peculiar pitch, and they ran completely flush with the side of the building. Meaning that the roof trusses were as wide as the roof were long, or as long as the roof was wide. The incident that we're here for occurred during the construction of twin buildings. They're sometimes referred to as 9A and 9B. These are 2 roughly similar buildings immediately side by side that Wilver Guzman, Nelson Mejia, the 2 plaintiffs, and their crew, who consisted of Isidro Alonso, and Albert Guzman, were constructing in preparation for putting the roof trusses on that we're here for today. Now, quickly, if I could give you an outline, just generally speaking, of who all the players are in this particular case. We have Peak Design, who Alan Moore represents, and that is owned and managed by Todd Fletcher. As I mentioned before, Peak Design owned, developed, and was the general contractor for the office park. They contracted with Rock Framing, Carmen Guzman. Carmen Guzman is the principal of Rock Framing, They contracted with him in 2016 to build all 16 of those buildings, or frame all 16 of those office park buildings. Now, Peak Design, Todd Fletcher, testified that he had no prior experience using cranes to lift roof trusses before this project. Now, going to rock framing, again, it's owned and managed by Carmen Reynaldo Guzman. Now, I'm going to interrupt my speech right here to tell you there's going to be some naming confusion. Anytime you hear Carmen Reynaldo or Carmen Guzman or Reynaldo Guzman, that refers to Carmen Reynaldo Guzman, who is the owner of Rock Framing. Also, there is a individual named Isidro Alonso, who is also known as Pelon. So if you're reading the transcripts provided, you will see that these are the same individuals. Now, as it was mentioned, Carmen Reynaldo Guzman owns Rock Framing, and he was tasked with building those 16 buildings. He hired the plaintiffs, Wilver Guzman and Nelson Mejia, to perform the framing on these two buildings under verbal contracts.
I saw those verbal contracts, and Wilver Guzman and Ronaldo Guzman are family, right? There's a reason why they're the same last name.
It is indeed. And also Albert Guzman is Wilver Guzman's brother.
Okay.
All right. So this is also the Cherry Peak office project was the first instance in which Ronaldo Guzman Rock Framing had ever used cranes to lift trusses onto the top of the building. Now, Wilver Guzman and Nelson Mejia. Wilver Guzman and his crew were hired by Rock to build those exterior walls and apply the roof on top of or put the roof trusses on top of the walls. Wilver Guzman testified that he had some experience with cranes, but we don't have the extent of that. However, nobody else on his team, not Nelson Mejia, not Albert Guzman, not Isidro, had any other experience putting up cranes. The injury occurred when a temporary center wall that Wilver constructed collapsed under the weight of roof trusses. Now, to give you sort of I guess a diagram, a schematic of how this worked, my clients, Almo Crane and James Edmiston, they get involved when Peak Design, Todd Fletcher, calls to order a crane. Okay. We come to the scene. We had done several lifts on different buildings before this particular incident. And on the date of the incident, we brought another crane out and this accident happened. Now, to give sort of a visual of how these trusses are generally lifted into place, you live in Travis County, so I'm sure that I'm showing you something you've seen 90 times in the last month. But generally, there are a few different ways of raising these trusses. When you have a crane like this, you either lift them up, set them down into place, and then tack it to the one before it, thereby erecting the roof sort of one little bit at a time. Now, trusses, as you probably know, are strong when you flip them upright because of the webbing of lumber and 2x4s that are within there. They have a lot of vertical strength. However, when you lay them down, it's like a piece of paper, they begin to bend in the middle.
Since some of us don't know a ton about construction, this is the general construction of a roof truss. What he's talking about is there's the top chords, the bottom chords, and then the webbing are those diagonal supports that go in the center of it that kind of make it sturdy once it's standing upright. But when you lay it down, it's kind of like flat, like a sheet of paper where it doesn't really support anything. Bonus fun fact, they're shaped like a triangle generally because that is the best way to evenly distribute weight. Triangles are one of the strongest shapes. I learned that in 5th grade when we had to take popsicle sticks and make them support a 10-pound weight. I failed miserably. The people who won made a triangle.
So I've given just some general examples of how trusses can be lifted on top of the roofs, one at a time in the top two, which plaintiff's counsel is arguing was one of their plans, Wilver Guzman's plans for the day. And then down at the bottom, another method in which trusses are lifted onto the roof and laid down, and then the framers themselves move the trusses one at a time and put them into place. Now, the incident itself occurred like this. This is the aftermath. These are pictures that were taken by Lakeway code compliance officers the day of the incident. Now, I mentioned earlier the temporary wall, and that was here. This was constructed by Wilver Guzman and his brother, Albert Guzman. And as the evidence will show, it was constructed on the suggestion or on the orders of Carmen Reynaldo Guzman. And we'll give you examples as to why. That was the crane line from the crane that James Edmondson was operating prior to the incident, or he had brought to the scene. And then lastly, these are the fallen trusses that were on the line at the time the temporary center wall collapsed. You can also see here, Judge, I don't know if you can see my cursor, right down below is another set or another bundle of trusses that had already been laid down and was part of the load that collapsed the wall. So knowing all this, it's important to kind of understand the plaintiff's theories of negligence, because this is critical to analyzing where the control lies and why the control is important. Both Mr. Moore and Mr. Hayalala, and I'm sorry, Andrew, I screwed up your name, I apologize. They both run with the first suggestion or the first theory that plaintiff has advanced, that the crane operator lowered the trusses too quickly, hitting that temporary center wall and causing it to fall. We are presenting evidence here in just a second, and it's in our motion as well, that shows that that's not probable. In fact, most likely impossible. Now, because of this, plaintiffs have put forward a second theory of liability, that the crane operator himself demanded that more than one truss was to be lifted at a time. We've had testimony from all of the individuals saying, well, you know, we wanted to go one at a time, but the truss, the crane operator said, I have someplace I need to be. I need to get back soon. That is contested. Our crane operator said that's not the case. I had nothing to do. I'm there hourly. I don't care. Leave me at the scene. So that's a contested point. And we do also have evidence to show that more likely than not, it was not our crane operator that decided bundles were going to be lifted. And then third, the plaintiffs, these are the plaintiffs, Wilver Guzman and Nelson Guzman are alleging that our crane operator should have issued a stop work order, an OSHA specific duty or operation by which a worker at a job site can order the entire work to stop if there is an unsafe condition or hazard taking place. Now, importantly, while the allegation is the crane operator should have done the stop work order, there also was the general contractor, Todd Fletcher, present, and then also Carmen Reynaldo Guzman, who are present for a lot of the same conditions, specifically the lack of fall protection, the plaintiff believes should have triggered the stop work order. Now, going back to the first point, the theory that the load was dropped, the only person advancing this theory is the plaintiff. And they're not even advancing it that much anymore. That was the first one, the first theory they advanced, and they began to back off of it. This is a different view of the same trusses. And importantly, this is the view that is telling. Now you can see right here are two slings. These are the straps by which the trusses were lifted. You can tell this one is untied. This one is not. Now, I presented to you in my response the affidavit of Dr. Jim Wythorn. Now, importantly, Dr. Jim Wythorn has been working in the crane and rigging industry for 45 years. He has a PhD that he got with a dissertation on crane and rigging accidents. He is the main committee member of the ASME, which is one of the premier safety organizations for construction, in particular cranes. And he works writing the safety standards for cranes, hoists, hooks, and slings, all of what is being considered here. He also is the author of the single largest crane accident database in the entire world.
That's his thing.
That's his thing. The man knows his stuff. And his opinion, which is provided in his affidavit and also in the report attached thereto, is that the shackles could not be opened with that while the trusses were under load. Now, this is obviously not in evidence, Your Honor, but I have one of those shackles right here. And they open and close with a twist. When they're under load, an immense amount of pressure is placed upon that pin that twists, and that friction, the pressure creates friction, and that pin won't open.
So that all goes against, and obviously the jury's gonna have to make the decision ultimately, but that all goes against the theory of that was dropped. That
Yes.
the trusses were dropped.
Exactly. And the reason why, and I'll shortcut this, is this is the reason why that's important. If the crane operator simply dropped the load, that's the crane operator's negligence. And you can essentially subtract peak design, and you can subtract rock framing out of the equation. And that makes it easier for you to make your decision. And that's why I'm trying to tell you, Judge, I'm sorry, I don't have an easy decision for you to make. Because the evidence is that is not the cause of the collision. As you see on the screen, the last line, we have the expert opinion that the reason why this wall collapsed was there was too much weight placed upon the inadequate construction. So the proof that we have is that crane, or that truss load, was laid down. Mr. Wilver Guzman walked out and unstrapped one of the two straps before the load collapsed on him. And Mr. Wilver Guzman and Nelson Mejia fell and hit the concrete slab beneath them. So the question now becomes, who controlled the lift and the number of roof trusses being lifted at one time? Now, here's where I begin to show the court, how there is evidence that Peak controlled the crane order.
Yeah, because I'm not hearing it right now. I have to tell you, I mean, it's very interesting and you're doing an excellent job, but this is where the rubber meets the road. So let me hear.
But I had to build the tire first.
No,
So
and you did a good job. You did a very good job with that. I appreciate that extra work that you did. Okay.
So I have 3 points here, and I'm going to provide evidence afterwards, but just to get the 3 points out as a guidepost.
Mhm.
Number one, Mr. Fletcher, Todd Fletcher, the owner and the manager of Peak Design, ordered the cranes from Alamo Crane Services 5 times, representing to Alamo that Peak Design Build was the customer. Okay.
Okay.
On prior occasions, and right here I'm going to disclose this, on prior occasions, not the instance in which this incident happened, but on prior occasions, we believe, and we have evidence, that Todd Fletcher signed contracts essentially saying that he had control over the work, that Peak Design had control over the work.
Mm-hmm.
And then the last is Todd Fletcher, specifically him, controlled the personnel who were available to be on the scene that day of the incident that could have aided in making sure that the lift was safer. Now, going into that more specifically, this is the testimony of Carmen Reynaldo Guzman as to who decided to use the cranes in general. Now, as you can see, when asked, he said the builder. That would be Todd Fletcher.
Mm-hmm.
He says Todd Fletcher decided to use the cranes. Todd Fletcher denies this, and he said he made a suggestion and Carmen Reynaldo agreed, which is essentially what is reflected there in the testimony.
Hang on, let me look at it for a minute.
Please.
All right. You may proceed.
Thank you. All right. Now, going to Peak Design being a customer, I have presented within my response the affidavit of Craig Nash, who is the safety director and a records custodian of Alamo Crane. And he has provided job tickets or a collection of documents related to each of the jobs that Peak Design had hired Alamo Crane on, including the one that we're here for today. Now, these particular documents are explained in those affidavits, but generally this is the job ticket. This is the order form that one of the dispatchers would have filled out. And it shows right here that the customer's name was Peak Design, the site contact was Todd Fletcher, and his telephone number.
And was this for you said there were other jobs, not this one so is this from a different job?
This was indeed.
Okay.
This was from the very first job, which was on, the order was created on April 4th, 2019.
Okay.
Okay. The incident occurred on April 29th, 2019.
Mm-hmm.
So I want to make sure that, I'm informing the court, we have a course of conduct in which there were separate individual instances in which Peak Design hired Alamo Crane to bring out the crane.
Mm-hmm.
But I'm using these as an exemplar, just in general, is what you'll see. And I'll show you the 2019 ticket in just a moment. But complete through these documents through A-3, we have Peak Design being filled out as the individual who are the customer for purposes of the crane.
And these are all different.
Well, to give you exactly what they are, this is the order ticket created by the Peak, or excuse me, by the Alamo Crane dispatchers.
Uh-huh.
This is an invoice and contract. This is what we'll be talking about a little bit more in a second. This is a document that the crane operators would bring out to the job site and have the customer sign off on to I guess for the amount of time and the amount of the bill and for certain terms and conditions of the lift. Again, I do not have one signed by Todd Fletcher for this particular, for the day of the injury. Now, this is the invoice, essentially just an invoice that was sent to Todd Fletcher to be paid after the lift was completed. And then this is a payment receipt generated when Todd Fletcher used his MasterCard to pay the $756 for the crane. Now, this is the job ticket for the date of the incident, which would be the August 29th date. And again, the customer is Todd Fletcher of Peak Design Builds. All right, now going further, the contracts affirming control. Now, this is that same document, but zoomed out a little bit. If you see there in the middle, there's all the fine print. It has a signature underneath it. But taking some of that fine print, you have copies, you can read the whole thing, Judge. But to exert or to take out some of the more important provisions is this language to the right. The customer shall have complete care, custody, and control of directing the manner and details of work. Now, remember, the customer here is Peak Design Build, and that the customer assumes all liability for the negligence, omissions of its employees, agents, subcontractors, other than Alamo Crane. Those are provisions that were signed, the evidence suggests and shows, by Todd Fletcher.
And was this, and that, did that pertain to this incident, that invoice and contract? It doesn't, right?
No, ma'am, it does not.
What you're saying is, but this is the type of thing they didn't happen to do it here, but this is the type of thing they did do. And you're saying it shows a kind of a pattern of conduct or customary.
A pattern custom of control is what we're saying.
Okay.
We're not saying that this contract applies directly to this particular lift, but we're showing that Todd Fletcher had control over these lifts by his affirmation of these agreements. And
okay. In other instances. Right.
Yes, yes.
Okay. All right. That's
but
right.
Also critically important. Okay. Remember, Judge, the Peak Design's theory is we have this contract, this base contract that we signed with Ronaldo Guzman in 2016, which says you have control over everything. We have nothing. Each and every one of these contracts that we have that we provided, A2 through I think A6, each of those were the ones that were signed within that contract period where Carmen Reynaldo Guzman allegedly had control over everything related to the construction or the framing of those buildings. So this contradicts that particular argument that we had by this contract dispelled all control and authority and never took it back. Now, to go to the theory as to this being Todd Fletcher who signed these two prior contracts, this is the affidavit that Peak submitted in support of their motion for summary judgment, signed by Todd Fletcher. This is the zoom in on that particular contract that I just had up on the screen.
Yep.
There are similarities. I have proven up both of these documents. There are similarities. Now, under the rules of evidence, once this court has determined that the signatures have been authenticated, not necessarily proven as true, but that there's enough evidence to go before the jury itself can make the determination as to whether or not those are the same signatures. Now, more than just presenting these two documents, one that Mr. Moore and Todd Fletcher have submitted to this court, and the contract that I have, that was a record that I produced. I also have the testimony of Carmen Reynaldo Guzman.
Real quick, let's take a look at the contract that you provided with Rock Framing and Todd Fletcher. Do you see the signature right up here?
Vamos a ver esta firma que proporcionó para Fletcher y para Todd Fletcher.
Sí.
La firma, yes.
Is that Todd Fletcher's signature?
Esa es la firma de Todd Fletcher.
Sí.
Yes.
So I have a witness in Carmen Reynaldo Guzman who has been working with Todd Fletcher for many years, has entered into contracts with him, who can testify to that being his signature. Now, going on to the third point, and this is related exactly to the work that was performed on the day of the incident. Peak was given the option when they made that order to have a rigger or a flagman, an employee of Alamo Crane, drive up with Alamo's crane and provide these services. That was asked, that was offered, and that was declined. And we have provided you the affidavits of 3 of the dispatchers, all of which had taken the orders from Todd Fletcher, who will tell you, I asked this question I offered this service every single time. If I don't, the order doesn't go through. And because there is no indication on any of the order forms that it was requested, I can tell you it was declined. Now, importantly, the reason why this relates to what occurred is a rigger is the individual who would strap the load up with those slings that I showed you. So they would talk with the customer, understand what loads needed to be lifted, where they needed to be set, and they would make the determination through training and experience to make sure that the load was properly strapped. Then, depending on who was there, the rigger or the flagman, either would assist in guiding the load and communicating with the crane operator to ensure the load was placed down exactly where it needed to be in a safe manner. When Peak Design declined this, they declined having a certified, experienced person from coming out and assisting with the load. Instead, the individuals who were out there working on the load were Carmen Reynaldo Guzman, who did not have any experience with cranes prior to the 3 or 4 buildings he had done before on this project. Wilver Guzman, who testified briefly, I've worked up with cranes before, but we don't know the extent of that. Albert Guzman, who had never worked on cranes before. Isidro Alonso, who had never worked on cranes before, and Nelson Mejia, who had never worked on cranes before. So in making this decision, Peak Design then controlled the safety of the project. And there was no margin for error on where to set these trusses, because as stated, the trusses were as long as the roof was wide. They go either way, about 5.5 inches, and the load weight is much, much higher on either of the 2 other walls that are holding up the truss. Because remember, we have the 2 exterior walls and that 1 center temporary wall. You move the truss one way or the other, that center wall is going to get a lot more weight placed on it. I've jumped ahead of my slides. The rigger and the flagman would have had more experience than any of these people. And that, again, by declining this support, Peak took actual control of the manner and the methods of the lift safety processes of the lift on the day of the incident. Now, that essentially wraps up my evidence that I provided in my response related to why Peak Design maintained some control over the lift that caused the injury. I'd like to just generally summarize. We have pre-existing contracts where Peak Design was the customer and had represented that he had control over the build or of the lift. Excuse me. And then we also have the evidence that Todd Fletcher, as Peak Design's manager, specifically declined having the personnel who would have aided in ensuring a safe lift.
Have you finished, Mr.? I can't tell if you've frozen or if you finished.
No, I'm sorry. I have finished. I apologize.
Okay, very good. All right, so that was helpful. Mr. Moore, now I think we're really honing in on these issues here. So what they're saying is that we've got these other contracts where they're saying that Fletcher/Peak maintain control, but that by their own admission, these were not pertaining to this case. They were others. And then then declining the flagman, which they're saying, well, look, you know, if Alamo had sent out their own flagman there, then that would have been a different story. Peak declined it, and therefore they maintained control over it, and none of those folks on on the site had experience with cranes, or if they did, it was very limited. And that's, Jerry could see that as a causative factor in the accident, and also foreseeable, given that Alamo obviously has experience with these cranes and the folks on the website, folks on the work site did not. All right, Mr. Moore, let me hear your reply.
Thank you, Your Honor.
Mhm.
Really, the issue boils down to, did Peak exercise actual control over rock framings, the means and methods of their work? Yeah, the evidence that they've submitted and what they're trying to hang their hat on here today is that we did not specifically request a rigger or flagman.
Yeah.
And I submit to the court that that goes to evidence, not of control, but that we don't control. It means if we had specifically requested a flagman or a rigger for this project, that would be evidence that the other side, Mr. Carl, would be presenting to the court and arguing to the court that that's evidence that we controlled this lift, saying that we actually hired and specified the personnel that had to be there. And so what we have here is where we did not make those specifications. As he said in the testimony of Mr. Carmen Guzman that he said, reference to the court earlier, Todd Fletcher, and Peak Design is the general contractor. That's one individual. That's Mr. Todd Fletcher, the owner of the company.
Mhm.
That's the entirety of Peak Design Build. He asked Carmen Ronaldo, Carmen Guzman, the
Mhm.
framing subcontractor, do you need a crane? And Carmen said yes. So based upon that representation and that Mr. Guzman said they needed a crane, yes, for purposes of this hearing, we certainly do not dispute that Todd Fletcher called Alamo Crane and they provided a crane to assist in this lift on this project.
Mhm.
As we specified, and I'm not going to go into too much detail with the court because I know the court has read the motion,
Mhm.
but Mr. Fletcher has testified that Peak Design had no communication with with Alamo Crane operator, James Edmondson, on the day of the accident, except he introduced him to Reynaldo Guzman. That was the extent of Mr. Fletcher involvement with this project. He did
I
not.
remember that in your motion. I saw that the extent of the communication had been an introduction.
Right. Mr. Fletcher, Mr. Fletcher at Peak, was not present at the time this accident occurred. He did not observe the temporary wall that was being constructed. And as you heard from Mr. Carl's presentation, that's the issue at the end of the day as to the cause of this, is that this temporary wall that the plaintiffs themselves constructed, Mr. Fletcher was not present at the time that was constructed. He did not observe it being constructed. He did not observe the lift taking place. He did not observe how many trusses were being lifted at a time. He knew nothing about the procedures and methods that they were operating at the time that this accident occurred, and only learned of the accident after it occurred. Reference to the court, Mr. Carl referenced, their own very qualified expert, knows what he's talking about. And attached to their response is not only Jim Wheathorn's affidavit, but also his report. And I think it's very telling as to his statements that he makes in his own report, and specifically on page 16 of his report. And Mr. Wheathorn, Alamo Crane's retained expert in this case, says the framing crew determines their own means and methods to erect the involved trusses. As a service provider, Alamo Crane worked at the sole direction of Carmen, Rock Framing, and Wilver, WG, that's the plaintiffs in this case. The framing crew determines their own means and methods to erect the involved trusses and provide directions to the crane for their intended placement locations. That's plaintiff's own expert. Basically stating what we've argued to this court is that Peak Design was not controlling the means methods that were being utilized by Rock Framing at the time of this accident. I would urge the court to read JLB case that we've cited in our brief. We think it's very similar, and we think it addresses and refutes all of the arguments that the that third-party plaintiff is making in this case. JLB involved a lawsuit against a crane operator and a general contractor and a subcontractor. And in that case, the plaintiffs were taking the position that JLB, as the general contractor, made arguments that they were on site every day, that they had a safety inspector on the site every day conducting safety inspections, that they knew that the crew was not utilizing fall protection, that they were not complying with their contractual requirements for safety, and just evidence after evidence. And the Texas Supreme Court, that the court will review that decision, says that is not sufficient to establish a duty on the part of the general contractor. And specifically, and I know the court referenced this earlier, with respect to the safety issue, safety harnesses, the general contractor has no affirmative duty to take action upon learning of an independent contractor's unsafe conduct. So I don't see how in the world that any type of duty can result on Peak Design Build in this case, when they were not present when this accident occurred, did not observe the scaffolding being constructed, don't know how it was constructed, knows nothing about its capability to withstand any particular type of weight, wasn't directing or communicating with the crane operator at all, wasn't directing how many trusses were to be lifted at a time. If you look at the JLB case, you'll see the similarities are unmistakable. There simply was not the sufficient degree of control exercised by Peak to result in liability.
All right, thank you, Mr. Moore.
Thank
Does
you.
anyone else have anything on this? I mean, I'll get back to you, Mr. Carl. I know you do. Does anyone else have any argument in this case? Or are we almost done with this motion?
Well, Your Honor, my name is Andrew Heilel. I represent Carmen Reynaldo Guzman and Rock Framing. We also filed a very similar motion for summary judgment, which I don't know if you want our arguments. We scheduled for a hearing today as well.
No, I saw it. I want to hear from you too. I want to hear, I've read your motion and I want to hear from you a little bit more though. But I think at this point, let me just stay where I am and I'll bounce back to Mr. Carl. We might have to take our morning break because my staff has been obviously online for a little bit and they need their mid-morning, run down the hall break because we all get very stuck here when we're on Zoom. But Mr. Carl, before we shift over to Mr. Halila, do you have any other comment pertaining to what Mr. Moore just said?
I do. And real quick, I know that Andrew, your last name is Finnish. Is that correct? Or is it Swedish?
I was on mute. Yeah, it is finished.
Okay.
And Judge, I call him Andrew because I just can't do it, and I apologize for that.
That's okay. Andrew, I think I can get to Halala. I obviously know a thing or two about difficult to pronounce last names. So, all right. So, Mr. Carl, what else do we have for the court?
My comment to what Mr. Moore said, and I frequently cite to JLB myself. It is a good case. However, there is a key critical distinction, something that's not included in JLB. That would be the rejection of the flagman and the rigger.
Mm-hmm.
Okay. Now, Mr. Moore, when he was addressing this, said that Mr. Fletcher did not request. Okay. That would be different. That is an affirmative request to get these personnel. What is happening here is Alamo Crane gave him the option and he declined. There is no evidence that he was acting simply as an agent for Carmen Reynaldo Guzman on making these orders. And so the evidence is that Peak Design through Todd Fletcher rejected the ability to bring these people out. I don't disagree with Mr. Moore's statement that Todd Fletcher was not present. Todd Fletcher did not build or direct the building of the central wall. The issue is that for this particular instance, the scintilla of evidence that we have brought is that Todd Fletcher controlled the personnel who are going to be on the scene by declining certified personnel.
And of course, I mean, it is speculative as to whether the flagman could have prevented this accident, but I mean, I guess I'm trying to decide if it's the scintilla or not. So what about the paragraph in the expert report that says that what did it say? The ground crew were the ones that actually have control over the framing crew, have control over the crane. What about that in the expert report? That was also, I thought, persuasive.
Well, I will tell you, if there was a flagman and a rigger there, that sentence wouldn't exist. Okay, the customer would have told the flagman and the rigger where to lift the load and set it, but anything between that point, when the load was strapped to the point the load was placed down and unstrapped, that would be entirely on the flagman and the rigger. So it's a distinction, but it's critical. I agree, as it stands right now, because of Mr. Fletcher's decisions, the control was entirely on the framers that day.
Mm-hmm. All right, very good. Anything else, Mr. Moore, since this is your motion?
Your Honor, just in closing, that's the key. That day, which the courts specifically talk about, the control has to relate to the specific activity that's occurring on the day of the accident. As Mr. Carl just said, that day, Carmen Ronaldo Rock Framing was the sole control of the means and methods that were occurring with that lift that day, and not Peak Design. You know, they talk about we declined a rigger, but Rock Framing had the ability to say, well, we're out here, we need a rigger, we need a flagman. That was never conveyed to Peak Design Build. There's no financial issue because those charges were being charged back to Rock Framing for the use of a crane that day. So there's no economic impact on Peak Design Build. Rock Framing controlled the means and method that day of conducting this lift, and the plaintiffs themselves. And that's the germane key issue in this case.
All right, very good. Okay, here's what I'm going to do, folks. Let's take a 15-minute break, and then we'll come back, and I'd like to hear on the other summary judgment then. I'm not going to make a ruling on this one just yet. I would like to rule fairly quickly, but I do want to hear on the other one first. So we'll come back at 10:30, and then we'll wrap up with the other summary judgment. Okay?
Thank you.
All right, thank you. All right. Okay, folks. So back from our break. Looks like we are still up on YouTube, which is good. Just before the break, we heard some excellent oral advocacy by both sides pertaining to a summary judgment that was filed by Peak Design Build. Now we're shifting over to a different one. This is third-party defendant's motion for summary judgment that was filed by Rock Framing and Carmen Ronaldo Guzman. May I please have announcements by movement?
My name is Andrew Hylala, and I represent Carmen Ronaldo Guzman and Rock Framing LLC.
All right, hello, Mr. Halala. Who else is here on this matter?
Christopher Carl here for Alamo Crane Services, Inc. and James Edmiston.
All right, very good. All right, Mr. Halala, you may proceed.
Okay. From the get-go, I did file a motion to strike a piece.
I saw it.
Okay. Would you like me to address that right now, or?
I think that's probably a good idea. Yeah, let's start with the motion to strike.
Okay. Well, apparently the plaintiffs had an independent medical examination back in September, which was court ordered, and no attorneys were allowed to be present. It wasn't transcribed or otherwise recorded. And at that examination, the doctor asked Plaintiff Guzman how the accident happened. And apparently the translator heard Mr. Guzman make a statement about what my client, Carmen Ronaldo Guzman, apparently thought about the project, but it doesn't say in the affidavit how Plaintiff Guzman came to acquire this knowledge about what he thought my client believed. So I think that the whole affidavit, Exhibit M, should be stricken, or at least the particular statement that Plaintiff Guzman made. He said in it, and I can pull this up if you'd like me to pull the affidavit up. Would that help?
Yes.
Okay, sorry. Okay. So right here, this is paragraph 3 of the affidavit of Cecilia Mejia, who is the translator. And my issue is this statement right here. Mr. Guzman was concerned because he believed the building should be built one planta at a time, but he deferred to his boss, who wanted all 4 or 5 plantas built at once. So this doesn't say that my client Carmen said that he wanted 4 or 5 plantas built at once. There's no foundation for where Mr. Guzman got this knowledge. It seems to be speculative, I think.
All right. And now this was at a medical examination with a translator there for the medical examination?
Yes.
All right.
Judge, if I could interject on that specific point,
Yes.
the translator is a counselor and works in the field for these medical neuropsychological IMEs. And so she's qualified, but she also has the training in medical Spanish translations. And so that's why she's the affiant. It's not through a translation. This is what she directly recorded.
All right, hang on a second. I need to turn on some heat in this office. It's really freezing in here. Just a minute. Okay, so this is a situation during the evaluation. Dr. Wisdom. Okay, so we ask him. I just don't really find this necessary reliable evidence for a summary judgment hearing, folks. What am I missing here?
Well, I think, Judge, you're missing that this is the statement of a party opponent. So Wilver Guzman is a party opponent to me. This is a statement that he made to another that was recorded and is being reported. Hearsay is a viable that an expert can rely upon viably, and they have relied upon this. And so this is his statement as recorded, as reported to you. This creates a fact question. Now, as to the speculation, there's no real speculation in there. The question is whether or not, first of all, is this what Wilver Guzman said? And there's no contest to that. He says that his boss told him a crane was coming. Now, that would be likely only Carmen Reynaldo Guzman, and that his boss wanted 4 or 5 plantas, and the plantas were,
Which he signaled and did this. Yeah, I got you.
Yes, plantas. Wanted 4 or 5 up at a time. Okay, that's the statement that was made. Now, as for the context for his knowledge, I don't have to prove this up at really at all, because he was at the scene. He's the plaintiff who fell. And as we'll show through quite a bit of other testimony, Carmen Reynaldo Guzman was there at the time too. So this is admissible as the statement of a party opponent, which is an exception to hearsay.
Well, I do know that, but thank you, Mr. Carl. It's always good to get a refresher on the rules.
Sorry, I cut my teeth as a prosecutor for the hearsay rules were big ones for me.
Yeah, they are certainly bigger among the criminal defense bar and the prosecutors, and they're among civil attorneys. Mr. Halala, how do you respond?
Well, it isn't a hearsay issue. It's a foundation issue and lack of personal knowledge. This doesn't say that Plaintiff Guzman, that Carmen Reynaldo Guzman told Mr. Guzman that he wanted all 4 or 5 plantas built at once. I don't know where Plaintiff Guzman got the idea that his boss wanted 4 or 5 plantas built at once. This statement doesn't say how Plaintiff Guzman acquired that knowledge. There's no foundation for it. There's no demonstration of personal knowege. So it isn't a hearsay.
I don't know if foundation is a requirement for an opponent's statement, opposing party statement to be accepted and admitted. And I think this court can probably at this point, take notice of the facts that Wilver Guzman was hired by Carmen Guzman, and would have the context for any of this knowledge through that.
Well, it's speculative. I mean,
it's the statement that's concerning me is here. Mr. Guzman was concerned because he believed the building should be built one planta at a time. but he deferred to his boss. Don't know how he does that, who wanted all 4 or 5 plantas built at once.
And I think this is just the nomenclature of the affiant. Deferred, you can also accept his meaning that he did what his boss wanted. He deferred to his boss's desires, which is what was evidenced by what happened.
Hmm.
I mean, this doesn't even say who his boss is. And I mean, he'd have no way of knowing what his boss's desires are. That the affiant very easily could have said, Plaintiff Guzman said that Carmen Rinaldo Guzman told me. It could have been worded like that, but it's not.
Well, Judge, all of this that we're discussing, speculative, worded a particular way, this is all a scintilla of evidence for a fact finder to determine later on.
Let me think on this one a little bit, guys. I don't know. I have concerns about this, and I know that we're in the scintilla business today, and that's all we've got. So then the other case that we just heard, in my view, we're really down to there was that failure to get the flag man there. Was that the scintilla? I got to read JBL before I rule on it, but it's teed up for me now. All right. So now we're looking at this one. Is this it? Mr. Carl, is this what we're hanging our hat on? Is the statement right here? Otherwise, there's nothing
It is
there.
not. This is mustard on my hot dog.
Really?
No, but importantly, you can't have a hot dog without mustard. It might not be that enjoyable. You have to Joey Chestnut it.
All right, very good. Mr. Halala, let's go on and proceed with your motion. I would like to hear from you, please.
Okay, so I think that the court's, intimately aware of the basic facts of what happened here and the arguments. So my client, Carmen Rinaldo Guzman, owns Rock Framing.
Okay.
He essentially acts as a general contractor. He doesn't have any employees. All he does is contract his projects out to different framing crews.
Mm-hmm.
And so Plaintiff Wilver Guzman is Carmen's nephew. So since at least I think 2013, Carmen and Rock Framing have contracted out with Wilver Guzman and his crew as independent contractors. And the course of dealing has always been that they are independent contractors.
But this is an oral agreement, right?
Oral agreement
between family members, right?
Mm-hmm. Yeah, and that Carmen and Rock give the independent contractors, total control, total reign over what they do and how they do it. So for this particular framing project, the plaintiffs were working as independent contractors. As you'll see in the JLB case and other case law, that in Texas, it's very clear that a general contractor doesn't owe a duty to his independent contractors underneath him. And this would also apply for, a first tier subcontractor to his second tier subs, which is in this case. The only exception is if there's a contractual right, which there's no argument has been made here that there's a contractual right. So the other exception would be if the general contractor, if Rock Framing exercise actual control over the injury producing activity. And in this case, I don't think that we have that evidence as a matter of law. Mr. Carl is going to present evidence, or I guess already has, that my client Carmen was somehow involved in the rigging of the crane, and that my client Carmen said that a center beam scaffolding wall to help support the trusses should be built. So my client Carmen disagrees with that. So there is a factual dispute there. However, even if you assume that everything that Mr. Carl is saying is true, that my client was involved in rigging and did tell the framing crew to build this scaffolding wall, well, those activities by my client were not they weren't the injury producing activity. As far as the rigging goes, there wasn't a problem with the rigging. The rigging didn't break. The load was not negligently rigged to the crane. The issue is that possibly, 4 or 5 trusses, the size of the load was bigger than it should have been. My client, there's no evidence that Mr. Guzman, that my client Carmen ever instructed anyone how many loads of trusses should be lifted at once. And there's no evidence that my client Carmen instructed on how this center beam scaffolding wall, this temporary support, that how it should be built. Mr. Carl is saying that he has evidence that my client said that this temporary scaffolding wall needed to be built. But the evidence is clear that my client didn't instruct anyone how to do it, and he didn't actually do it himself. So that was the framing crew that did that, not my client. So the level of control that they are alleging that my client actually exercised, I don't believe that, as a matter of law, I don't believe that it is close enough to the activity that produced the injury. My client was at the construction site that day, according to him, just as a very general supervisory role that you'd expect a general contractor to have, just to show up at a site and to make sure that everyone is there. If they're being paid, that they're there to do the job and that it's getting done. So, my client's position is that he was there just in a very general role, and that even if everything that Mr. Carl is saying regarding my client doing rigging, or my client saying that a temporary scaffolding wall should be built, that just isn't close enough. That isn't the injury producing activity. The injury producing activity is that this temporary wall was built poorly by plaintiffs, not by my client. That's basic summation of our argument here.
Okay, very good. Thank you, Mr. Halala. Mr. Curl, let me hear your response.
Well, first, I'd like to dispel the idea that there are multiple generals at this particular work site. Mr. Halala, Andrew, has referred to his client as basically a general contractor, and that's simply not true. Okay, he is a subcontractor who did a sub to other individuals. All right, and he did so without a written contract that provides any of these provisions that he's relying on. So now it's going to come down to just simply the belief as to whether or not he somehow was able to dispel all of these responsibilities and liabilities to an independent contractor who, frankly, we don't even know if they're an independent contractor. And no evidence has really been produced other than a very interested witness's testimony in the form of Mr. Carmen Ronaldo Guzman's affidavit. Now, generally speaking, when we focus in and say the reason why this accident happened was the wall was improperly framed, that is the ultimate point. However, you have to work backwards. You have to work backwards to the lift plan, how the trusses were going to be lifted, and what the design was. And we showed you generally what the plan would have been by lifting those trusses up and how they would have been placed down. Now, that affidavit that you took a look at, that you're questioning, relates to who made the decision to put down multiple trusses in a bundle. This is important because if you're laying them down in a bundle, you are not setting them up one at a time to where they could hold their own weight up.
They're very heavy.
And they bow in the middle.
Mm-hmm.
So if you had one at a time, that truss can expand the entire span of the building without any need for internal support. That temporary wall is suggestive, it's probative of the fact that these were going to be laid down. Then the question becomes, who had control over it being a bundle? Now, one of those documents I provided you before, I believe it is Exhibit A6, that it's one of those bundles of the work product, shows that Todd Fletcher ordered the crane to lift bundles of trusses. Bundles. It's written down in the work order, bundles of trusses. When you go back and look at the other work orders from times past, they do not say bundles. Bundles is important for crane operators because it signifies how much weight's going to be on the end of their boom. The more weight, the further out it goes, the better chance you have of tipping. So the weight of the load, what's being lifted, is critically important. So bundles of trusses were ordered when this crane came down. Now, to adopt Mr. Moore's position that Mr. Fletcher was conveying the order of Carmen Reynaldo Guzman, couple that with the evidence that we presented you that Wilver Guzman nor any of his people were present at the work site prior to the construction of these two buildings, it vectors in that it was Carmen Reynaldo Guzman who made the determination to lift bundles of trusses. And those bundles are heavy and they require internal support. Now, with that preface, I have more slides, Judge. May I present those too?
Yes.
Because we are going to be, the facts are roughly the same. These are mostly just argument points and deposition transcript. So generally, we're going to show, the evidence does show that Rock controlled this crane lift, the entire crane lift, which is the ordering of the crane, the strapping of the bundles together, the setting of the load down on top of the structure, and that he, as the employer and the person in control of the framing, should have handled more, I guess, recognized hazards, but he was exerting control, and from that, this injury happened. So the first point, he ordered the construction of that temporary center wall. And we'll show you the testimony. He knew that there needed to be a temporary center wall because of the prior lifts that they had done. Recognized that there needed to be something placed in the middle. Wilver Guzman had not been on any prior site, and he didn't have any idea. By that fact, we can deduce and reduce the numbers of individuals who might have had control over saying what center wall needed to go up to Carmen Reynaldo Guzman. And then further testimony we showed you, Carmen Reynaldo Guzman gave no specifications, no designs, no plans, no engineering reports, no idea of how it was supposed to be constructed. He ordered the lifting of bundles. Now that affidavit that is reporting Wilver Guzman's statement is part of that evidence, but we have more. And he, by the way, in this instance for this list is Carmen Reynaldo Guzman. Also, he rigged those roof trusses. Now, okay, the theory plaintiffs are advancing is that the crane operator said, I got to get home. You need to go and bundle 5 or more at a time. Carmen Reynaldo Guzman was the boss on that job. And if he's rigging them, he's the one who's ultimately putting those 4 or 5 together. So he had a role in assembling those bundles. And the last is, and there's testimony on this, he directed the crane operator where to set those bundles of trusses. So he set those 2 bundles of trusses close enough together where they put stress on that temporary center wall, and the wall collapsed. Now, to the testimony of who ordered the center wall, Albert Guzman is Wilver Guzman's brother. Wilver Guzman says that Wilver Guzman and Albert Guzman built this wall together. Here's the testimony right here where you can see that this was Carmen Guzman's order or idea. He says, well, Wilver and Carmen, I don't know, Carmen decided to put up the temporary center wall because Carmen had already done 3 previous buildings. So by experience, he thought that there should be a scaffold in the middle. Scaffold and temporary center wall are essentially the same thing. So Carmen had built 3 other buildings before y'all made it on the job site. Yes, he'd already built them. All right. And did he use another contractor or subcontractor, not Wilver, for those projects? Yes, his own workers for his company. All right. And your understanding is that Carmen had learned a centenary temporary wall was necessary to install the trusses. Yes. Did Wilver work on any of those three previous projects? No. Therefore, the only earth that this idea could have budded from is from Carmen Guzman and his experience. Now, again, deciding to lift the bundles. Number one, we have those exhibits that show that bundles of trusses were put on the work invoice on A6. And then also we do have this affidavit, and I understand the court's concern, but this affidavit remains a reflection of the statement that was provided to this certified translator regarding who made the determination. And by argument, his boss informed him, Wilver Guzman told this translator, his boss informed him that a crane was going to come. That presupposes the crane was not there. And then two, and also another instance, he does not refer to Todd Fletcher as his boss. I believe he calls him the white guy. And then two, also the boss referred to again, wanted 4 or 5 lifted at a time. That's enough of scintilla of evidence by that statement to be able to show that a boss, and the determination of who is most likely Carmen Rinaldo Guzman, wanted the 4 or 5 lifted at a time. As for the question as to who the boss was, Wilver Guzman, in his request for admissions, admits that he was an employee of Rock Framing LLC at the time of the incident. This does 2 things. Number one, it shows who's the boss. And number 2, it shows the question as to whether or not this really was an independent contractor relationship. We don't have a contract from Andrew or from his client to show that there were those delegation of liability of safety requirements, of safety training, of safety procedures, of making sure everything was performed in a workmanlike manner. Now, here's the testimony of Wilver Guzman. The load of trusses that fell in the picture, Exhibit 1, that's the first picture that I showed you, Judge, where I had outlined all the materials that were at the work site. The loads of trusses that fell in the picture of Exhibit 1, who rigged those trusses? Reynaldo Guzman and Isidro Alonso. Reynaldo Guzman rigged the bundle of trusses that ultimately fell. That's evidence right there that he's the one who put 4 or 5 trusses together at that point and had them lifted. Because here we have the biggest point. Wilver Guzman's deposition. Who directed the crane operator about where to set the trusses down? Reynaldo. We were just directing them and pushing them a little bit. Reynaldo was directing where to put the trusses. Reynaldo Guzman, through this testimony, through this evidence, exhibited complete control over this lift and ultimately the cause of this accident. Now, we talked about this a little bit, and this is a part of my response that I'm not going to argue hard here. But Mr. Moore was talking about JLB. The general contractor with a contract does not have the duty to stop work even if he sees a hazardous instance going on, including lack of fall protection. JLB is not applicable here because we don't have a contract.
Contract, I know, that's exactly what I was thinking. Go ahead.
So, my apologies, Judge. So right there, Carmen Reynaldo Guzman was present at the subject lift, watched his guy standing on the top of that wall, not wearing fall protection, had immediate control over those guys, and did not stop work. And now plaintiff is trying to blame the crane operator, whose job it was to lift a load and to set a load where he was told to set it. That because he didn't stop work, he's responsible for this, for all of this. That's the theory that plaintiff is putting out there. And this is where the position of the parties is critically important. My claims against Rock and against Peak are for contribution, that their conduct contributed to any of the losses that my client might have through this lawsuit. Should we prove that there's any negligence or any sort of negligent conduct that contributed to those injuries that the plaintiff is sued over? And so I am essentially a vessel for plaintiff's allegations of negligence against me. And so as this vessel, I am showing this court the negligence of Rock and of Peak and how their conduct exhibited control over this lift, which is the lift itself is the injury causing work. So I think after seeing the testimony of Wilver Guzman, recognize that statement from the for the affidavit from the IME.
I'm sorry, could you step back a page? So the courts are so busy that we're communicating with each other back channel in other cases. And I got distracted for a second. So it's just it's a Christmas holiday thing. Just
Sure.
go back to what you were just saying.
What I was saying is the way that this litigation is postured.
Mhm.
My clients have filed third-party claims for contribution against Mr. Moore's client, Peak, and Andrew's client, Rock.
Right.
Okay. I am a vessel for the negligence causes of action brought by plaintiff's counsel.
Yeah. Yeah.
My action against the third-party defendants here is to show that their acts
Yeah.
contributed to the conduct that caused this injury, thereby having them be liable for the contribution of any damages
Mhm.
I'm going to be responsible for paying for.
Yep.
And so I am confident that the court will see that I have presented more than a scintilla of evidence on all points, that the lift itself, which would be the crane on the site that day, lifting those trusses that day, there were elements of control by Rock, quite clearly, and by Peak for my prior arguments.
All right. Very good. Mr. Halala, do you have anything by way of reply?
Well, I do want to address the request for admission issue. So my client was brought into this litigation probably halfway to a third of the way through the litigation. So that request for admission that he showed you, I really wasn't aware of that. I don't think it was ever provided me until the MSJ response here. But even then, even if the court thinks that that creates a fact issue as to whether someone was an employee, there's two plaintiffs here, and that RFA was only directed towards plaintiff Guzman. It wasn't directed towards plaintiff Nelson Mejia. So even if the court thinks that creates a fact issue as to the Rock Framing being the employer of plaintiff Guzman, I mean that doesn't affect the independent contractor oral agreement that Rock Framing had with plaintiff Nelson Mejia.
All right, very good. Does anyone else have anything else to say on this particular motion? All right, very good. So here's my ruling on this, on the current one, Mr. Halala's motion. And I'm going to have to go, before I rule on Mr. Moore's, I'm going to have to go read JBL. Pertaining to third-party defendants' motion for summary judgment, third-party defendants being Rock Framing and Carmen Ronaldo Guzman, collectively referred to as third-party Rock defendants or movements on their summary judgment. The objection to the summary judgment evidence provided in response is denied. The motion for summary judgment is denied. Mr. Carl, please provide me with an order pertaining to that. Regarding the other summary judgment motion, I will be ruling in all likelihood later today, but I do need to go look at JBL. Parties have done an excellent job providing these issues. I will say, as you get ready for trial, just make sure that you have good, easy ways to refer to each of these parties, because the jury could get bogged down in some of these things. I've had to keep very careful notes. All right, with that, I'm going to be now jumping off the Zoom call so I can get to some other things, but I will be giving a ruling. Mr. Carl, you need to just submit an order, please.
Absolutely. And Judge, may I ask one thing? Would the court entertain a very brief letter highlighting the distinctions between JLB and the arguments and the evidence before the court?
The thing is, though, that you get that to me, and then Moore gets his chance to do his piece.
Exactly.
So if you've got something to say, now's the time to say it. Okay.
I tell you what, may I defer to my esteemed co-counsel David Lewis, who made a good point in the break that JLB refers more to Mr. Lewis. It's less about control and more about. You're on mute, sir.
Yes, sorry, I was not really prepared to go into it. I was
Do your best.
on JLB as we speak. What I see so far, JLB sets the framework on whether there is a contractual retained control and if there's actual control taken in light of a contractual agreement. However, I believe the emphasis should be on the actions taken outside of the contract agreement, even though JLB does go into it, but it does not address a circumstance where in which JLB focuses on the safety requirements. This here, Peak took actual affirmative steps beyond the contractor agreements. The way I'm reading JLB is asking, is talking about compelled action, trying to compel an action from a contractor in light of a safety thing. Here, they took an affirmative step beyond what they're required to do.
Yeah, I hear what you're saying, that JLB, now I've not read the case, but what you're arguing is, okay, yeah, but see JLB, there was a contract and the safety steps that are, I don't know anything about it, but whatever safety steps weren't taken, harnesses or something of that nature, those were apparently part of the contract. And what you're saying is, yeah, we'll see in this case, there was a step that was taken, an extra step that was taken that was kind of outside the contract, which is Alamo Crane saying, do you want us to send a, what was it called? A flagman or over? And the answer to that question being no, right? Okay,
Yes, Your
Mr.
Honor.
Moore, let me hear from you on that.
Yes, Your Honor. Yeah, in the JLB case specifically, the requirements of the contract by the general contractor mandated the use of safety harnesses. That's what the
Yeah.
general contractor in that case specifically mandated.
Mhm.
And the evidence produced by the plaintiff in that case was that the general contractor, despite mandating that, had personnel on site who observed the fact that safety harnesses were not being utilized. So they had that direct knowledge that their own contractual requirements that they required under contract were not being followed. And the court said that is not sufficient to establish the degree of control.
Mhm.
And so, and for various reasons, as you'll see when you read the case, Your Honor, but specifically first, requiring a safety measure and anything that you require would actually have to increase harm, not decrease it. But the court specifically stated that general contractor has no affirmative duty to take action upon a learning of an independent contractor's employees' unsafe conduct.
Yeah,
And
yeah.
so, I mean, you read the case, I see no distinction between the law as outlined by the court in that decision and the
Yeah,
first.
it certainly does seem to be a sea change, that case, in some way, from what I could gather with the small bit of research I did on the break. I didn't have time to read it. But I do know that it was a definite change in direction. So, folks, I need to read that case before I make a ruling on this, which I will do. And I hope to get back with you all as soon as I possibly can. I would like that to be today. I don't know if it will be today because we have right behind you all this afternoon, more people coming in. And as much as I'd like to spend the lunch break doing this, we've got some other duties at lunch that take us away from the court a little bit. So, so hopefully I get it to you before the holiday. My goal is certainly to do that. Okay. All right. So that's where we are right now. Mr. Curl, please draft that order on the other motion and the summary judgment evidence that you provided. Please provide that to, so it's 455.submission@traviscountytx.gov. And I think Travis County TX is all one word. Okay.
All right, wonderful. And when you say the evidence, you want my responses with all of the exhibits?
No, the only thing that he had made an objection to your evidence, and I overruled the objection. So that needs to be in your order. Okay.
The order submitted. I'm sorry. I thought you wanted, I understand now.
No, just the order denying the summary judgment and denying his objection to your summary judgment evidence. That's all I need. Okay.
Thank you very much, Judge.
All right. All right. Very good. Thank you both for your, I don't know if Mr. Halal is still with us, but thanks to everyone for their thoughtful arguments. Mr. Lewis, thanks for jumping in. Everyone's done an excellent job on this case. I do suspect that, have you all had an opportunity to mediate, or were you waiting for the summary judgment hearings?
It's not related to the summary judgment hearings, but I think we're still having scheduling issues with depositions, and that mediation is still being discussed.
We have a herd of cats, Judge.
Yeah, you do. Boy, construction cases are like that. There's just nothing worse, but certainly in terms of trying to herd the cats. All right, well, do you have a trial date in this case, or I think it looks like Judge Hurley gave you a docket control order?
We do. I believe it is February 26th, but we are rapidly approaching the point where that's becoming not very feasible.
Wow, sure is. Okay, well, you all, stick with it. If you do, an agreed continuance is close to trial, but where you all are, it's a complex case. It is an older case anyway. Take that seriously, because I hear where you are, but I don't know who you're going to get on that day. So I'm just letting you know, be serious and keep that in mind. So keep this on the front burner. Okay, I'll get back with you all then later today. All right, thank you.
Judge.
Thank you so
Bye
much,
now.
Judge.
The following day, the judge issued 2 orders denying both of the third-party defendants' request for summary judgment. There have been no additional filings in the case, and it's slowly inching forward. It was initially filed in August of 2020, and it doesn't look like it's going to trial anytime soon.